Welcome everyone to the first of our three-part series on the Feldman family. We are very lucky to have three experts who will moderate this over the next 3 Wednesdays for all of our members, both of NAFA and the Society of Financial Services Professionals. But before I get started, I would like to ask everyone to keep in their hearts and prayers our friends and colleagues and families all along the Gulf Coast that was devastated a couple of weeks ago by Hurricane Laura and over the last few days by Hurricane Sally. As has been NAFA's history, we will again reactivate our Hurricane Relief Fund. Information will be coming out about that in the next couple of days from NAFA National. I'm also very happy to introduce my good friend, Rob Wellendorf, who is the current president of the Society of Financial Services Professionals, and with whom we have had a wonderful partnership these last couple of years on advanced practices. We'd also like to thank our sponsors for today, Pacific Life, Mutual of Omaha, and Beacon Financial. And with that, I'd like to turn it over to Rob and let him introduce our first speaker and introduce the Society's GO program. Rob?
Keith, thank you. And to all, welcome. Again, the opportunity to partner with NAFA and the Society of Financial Service Professionals to bring this type of education is creates a lot of energy, definitely for the Society and NAFA members alike. Keith had mentioned, thank you, a new initiative. It's, I think, a wonderful opportunity for both members and non-members to access the quality educational programs and content that the Society has been known for over 93 years now. So I would encourage you, when you have the opportunity, to check out FSP Go, fspgo.com. That's Foxtrot Sierra Papa Go.com. And again, you'll see all of the educational content, from articles to subscription to the journal, as well as a multitude of webinars, and they are organized by topic or topical areas. So I think you'll find that very exciting to have access to, again, those advanced markets programs. Regarding our case study today, again, in a 3-part series, you all should have the fact pattern about the Feldmans and their business with you or in front of you. I do want to point out, I guess, just a couple highlights to keep in mind as we're going through our session today. Jack and Diane, as we may refer to as Mom and Dad, have owned Synergy Consulting for many, many years, goes back to 1984, a relatively small company in terms of number of employees. They currently have 12. The family dynamics that make these cases most interesting, we should mention the Feldmans have 4 children. They have Abel, Patty, Sheldon, and Keegan, and their ages range anywhere from 47 to 39. And again, what you have in front of you with the fact pattern, we see that Abel, the oldest, age 47, he's the senior sales director and has shown an amazing ability to recruit new customers. Their second born, Patty, she's 45. She's the COO and has shown incredible talent and skill around the internal operations, and of course has earned that title of COO. Then we have Sheldon. Sheldon is Patty's twin, so also age 45. And Sheldon, they really have just tailor-made a position for him. And you see me smiling, and they've titled him the Innovation Strategist. And then the youngest, Keegan, age 39, he's not involved with the business at all. And as you read in the facts, has had perhaps some challenges and issues. I think if we're, and as much as we avoid labels, as we see in the real world, he may be considered that a challenging child or a difficult child, which adds, of course, many aspects and elements of looking at business succession as well as fair and equal. I should also mention in the fact pattern that I think will be significant as we look at the issues that Ron will share with us today. We do have a key employee who's non-family. Her name is Maya, and she's the VP of Strategic Operations. Continues to be considered the most valuable employee for Synergy, the company. As far as the current plans that are in place for Generation 1, we're showing that they have durable powers of attorney, they have living will, and then also a basic I love you will. Should also be mentioned in the facts, we do have a $2 million second to die permanent life policy that's in an irrevocable trust. And that goes back to 1995, and the trust beneficiaries are all 4 children to be treated equal. So that will set up the fact pattern a bit. Before I introduce Ron Lee, our speaker, I do want to mention at the bottom of the screen, you'll see the Q&A. There's a little Q&A button. We're going to utilize that Q&A for you to offer the questions, and I will batch them and we'll try to handle all the questions at the end. So with that being said, let me go ahead and introduce Ron Lee. Ron is currently the Vice President, Advanced Markets and Brokerage Field Relations for Mutual of Omaha Companies. Ron has a law degree from Creighton University. He's been extremely active in the Society of Financial Services Professionals, the Omaha Estate Planning Council, Association for Advanced Life Underwriting, and he's the former chair of LIMRA's Advanced Sales Committee. Ron, when we read through the fact pattern and look at all of the issues, you're a phone call away. You are the expert, so we look forward to hearing from you as you walk through Generation 1 of the Feldmans. Welcome, Ron Lee.
Great. Thank you, Rob. And thank you, Keith. Welcome, everybody. Thank you for coming this afternoon and joining us to talk in part 1 about our friends, the Feldmans. And let me just kind of lay out how we're going to handle this. We're going to talk a little bit in each week about each generation. Okay, so I'm going to be talking about Generation 1 or Jack and Diane. And of course, you know that with Keegan being the problem child, as Rob indicated before, that he's going to come into the planning everywhere. So you will hear a little bit about Keegan today, but today is primarily about Generation 1 and talking about Jack and Diane. And just so you know, the way that we approach this is going to be a little different in the next 2 weeks. So since I had Generation 1, I decided to go with the estate planning angle because there are so many issues that they can address with their estate planning that I thought, well, let's get them all on the table. And so we'll be handling a lot of issues over the next 40 minutes or so, 45 minutes. And in the following 2 weeks, I think Kathleen and Andrew will probably be talking about less issues, but they're going to go into some more detail than I am today as far as specific planning concepts. So the first thing I wanted to do is to advance my slide, of course, and there we go, is to let you know a lot of you are here for continuing education today. And I want you to know that you have to watch for the survey questions. We don't know you're there if you don't. And so they are going to be necessary for the CE credit. And I've got to tell you, it also just makes sense. It's good to know what the other people that do the same work as you are thinking about a particular idea or concept. So please participate in those. And of course, if you want CE, then you need to do it anyway. Survey question number 1. Putting a survey question immediately after the reminder to watch for the survey question is A, hilarious, or B, don't quit your day job. Let's just take a minute and see what kind of answers we get there. Okay, why don't we go ahead and take that down and see if we got some answers there. Okay, well, 67% of you thought it was hilarious, and 33% said don't quit your day job. And I hate to say it, but the 33% probably is the correct of the bunch. But so thank you for that, and that is important. Make sure again that you are answering those survey questions. We'll have some serious ones for you later on that will inform what we're going to talk about. So as I indicated, we're going to talk primarily about the estate planning for Generation 1, Jack and Diane. And we'll talk a little bit about business succession planning, but really only in regard to beginning the conversation as we talk with Jack and Diane about things. So estate planning is challenging, right? For those of you who don't do a lot of it, it can be very intimidating. And the reason it can be very intimidating is that you don't necessarily know everything there is to know about estate planning. You couldn't. So if I did another polling question immediately after this and said, hey, what do you think is better, a grantor retained annuity trust or a sale to intentionally defective grantor trust? I would guess that most of you would say, I don't know. And you know what? That's okay. That's okay. We don't have to know. I will tell you, I've been doing this for about 20 years. And if you want to know the number of times that somebody has asked my opinion, outside counsel, how many times I've asked my opinion on whether they should do a GRAT or a sale to an intentionally defective grantor trust, the answer is 0. They've never asked. You have to partner with the attorneys. You tee these issues up. So if you're going to talk about estate planning, I think it really only has to have 2 primary phases. And that is, number 1, disturb people into taking some action. That's your role, right? You're out there seeing people. The attorneys, the CPAs, they aren't calling people as a rule and saying, hey, you need to come in and see me to get your estate planning done. You guys do that. And that's part of the service that you provide. So you disturb them into action, you try and get them to go see the attorney and the CPA, and you participate in that plan to the extent that you can. So that's all part of 1, all part of disturbing them. Number 2 is fund the plan. That is what you guys do that nobody else can do, right? You can make the most wonderful, elaborate plans in the world, and once it runs out of money, then it's done. It's done. There is no estate plan that works without money. People will set up these great plans, and these great plans will have a summer home going to one child and another piece of property going to another child. But you know what happens when the estate runs out of money? They sell those assets and nobody gets them. It's the same thing with a retirement plan, same thing with the long-term care plan. It doesn't matter. As soon as a plan runs out of money, the plan fails, no matter how good it was to start with. So you should not discount how important it is what you do. You're the only one who walks in with a check. And that is the one thing that will either salvage a poor plan or save a really good plan. So when you're disturbing people, what do you do? I mean, how do you get started with this conversation? And I think as part of your fact finding, one of the first things that you should do is find out what they've already done, right? And Rob already told us that they've done a little bit of planning. And here's what they've done. They've done I love you wills. And for those of you who don't know what an I love you will is, basically what it says is, I talk to my wife and I say, you know what, I love you. So if I die, everything is going to go to you. And if you die because you love me, you're going to give everything to me. Now, we used to speak of this a little bit derisively from time to time because if people had an estate tax issue, sometimes that wasn't the most efficient way to transfer your estate. You had to make a provision for using both of the exemptions available. But now we have a thing called portability, which we'll talk about in a slide or two. And so a lot of that has gone away, but we still have the I love you will as the standard that really most people are doing, honestly. We know they've done durable powers of attorney. We know they've done living wills. And we have a 1995 irrevocable life insurance trust with a second to die policy. So the good side is we know they've done some planning. We know they're open to doing planning because they've done it before. The downside is we don't know if they've done any planning in 25 years, right? There's a lot of people who don't address their estate plan more than every 25 years. It's terrible, right? We tell people do it at least every 5 years, but people don't listen. So it is entirely possible they have not done a thing yet. Okay, so now we know what they have done. Let's talk about some things that they should consider doing. And personally, I think when you're starting estate planning, you should start with the simplest thing and work your way up. And I think that's really important because especially, maybe it's because people bring things to advanced markets that are advanced or technical or challenging, but we see people who try and address the craziest and most difficult issue they can first. And then later you find out that the people don't have a will, right? So let's start from the beginning. Let's take the low-hanging fruit and talk about these things. Let's say, do you have a will? And if they say, well, what does a will do? Why do I need one? The answer, of course, is that you need a will because that indicates where your property is going to go after you die. In addition to that, you should do a will if you have minor children because you can nominate a guardian for those minor children. But of course, Jack and Diane don't have minor children, so they don't have that issue. But they can also nominate a personal representative. And a personal representative is a person that is charged with winding up your affairs in probate in a way, hopefully, that you would have wanted them to wind up those affairs. So that's a really difficult job. And I encourage people when they're thinking about that to think about someone who, one, knows what their wishes are, but number two, would also be inclined or have the ability to actually be organized and get these things together. It's a difficult and challenging job, and so you have to find the right person for it. The next thing, of course, is a power of attorney. A power of attorney is a document that gives a person, an agent, an attorney in fact, the ability to act on your behalf in your legal and financial matters. And you do that, you can either have those effective immediately or effective upon becoming incapacitated. And if it's effective immediately, then you can have it either it survives and continues on beyond incapacity, or it can stop. I will tell you, almost everyone that I've ever known drafts them in a way so that the power of attorney takes effect when they become incapacitated and continues from there. But that's a really important thing. The next thing on here is a living will. I don't know how many of you are familiar or remember the Terry Schiavo case, but with the Terry Schiavo case, this poor woman fell into a persistent vegetative state back in 1990. Right? And she did not have a living will. A living will is a document that indicates what your end of life issues are, or end of life wishes are, excuse me. And she did not have one. So when she fell into a persistent vegetative state, her husband and her parents had different ideas. Her husband wanted to remove the life support. Her parents did not. They fought this for 15 years. 15 years. And regardless of how you feel about that particular issue, it doesn't matter. If Terry Schiavo had been approached by someone and had executed a living will, then she would not have had that situation. Either she would have continued on or she wouldn't have, based upon the wishes she expressed prior to any of that happening. There's also the medical power of attorney. That's also called a healthcare power of attorney. This just allows someone to act on your behalf if you're not able to make your medical decisions. And then finally, a lot of people might need a trust. A trust is pretty complex in application, so we won't spend a lot of time, but essentially you are giving property to somebody to manage for the benefit of a beneficiary. And so these are all great documents, great planning things to consider. And Jack and Diane need to start with that, because once we start with that, if we start with taxes, for example, people just get turned off. Nothing gets your heart racing like taxes, right? It doesn't happen. So talk about the stuff that really matters. And once you finish talking about those documents on the previous page, you're going to know what matters to these people. And there's another reason why you don't want to start with taxes. Look at these numbers. $11.58 million per person, $23.16 million per married couple this year in 2020. That's a lot. I'm going to be honest with you. We don't have a lot of people come through with that big estate. Some of you may not have anybody with that big of an estate. So a lot of people don't feel like they're going to have to pay it. And that is a bit of a concern, right? If you start out with an estate tax conversation and people don't think they're going to pay estate taxes, then you're picking up your briefcase and you're walking back out the door. So one thing I would mention, of course, is that this does sunset on 12/31 of 25. So if you die on January 1st of 2026, you're back down to 5 million, and that's indexed for inflation. So I think the question to ask Jack and Diane at that point, if they say, well, we know that Jack and Diane have about a $23 million business, right? So they're over the exemption anyway. But some people might say, you know what? I think that I think it'll go up, or I think that I don't have to worry about it, or my kids can just sell something because it's not much. And I think the question you have to go back to them with is, okay, but will both of you die before January 1st of 2026? Because if you don't, it's back to 5 million per person, $10 million per couple. Now, I do want to take just a brief aside here, and that is to tell you about portability, because this is going to come in a little bit more. Back in the day when people were doing their I love you wills, as I indicated, if you left everything to your spouse, then, and you can leave everything to a spouse without paying any estate taxes, but then eventually your spouse would die and they would only have his or her exemption to go with. So in this case, if Jack died and there was no portability, then basically they would have just lost $11.5 million worth of exemption. But now we have a thing called portability. So if Diane, if the personal representative for Jack in this particular case files an appropriate election after he dies, she gets to take over his unused exemption, currently at $11.58 million. So it's just determined in the year that they die. So portability is a great thing, but I'm still back to the fact that, all right, well, in 2026, this is going back down to 5 million per person. And depending on what you think is going to happen in November, you may even see it go back down before that. So I think that when people pretend like they're not going to have an estate tax problem, they might have one. So what do? Here's what I think you do. Number one, you put them into categories, if you will. You separate the ones who will never have an estate tax problem because they have other more important issues like protecting their mortgage and income replacement and things like that. You have a group of people that will definitely pay the estate tax, and that's easy. Your challenge comes when you have people who are in that middle area. They might pay it, right? Their estate might grow enough to pay estate taxes. The law might change to where they would pay it even though they don't have to pay it right now. That's where the challenge is, but that's where you come in and you can help people understand that you still need to manage it, because a 40% estate tax problem is a huge problem for your family. So how do we manage that? Well, number one, we could just come in and start talking about buying life insurance, right? Because life insurance is a slam dunk, and almost everybody agrees to that. Now that it's a slam dunk for paying estate taxes. But if you go back to a client and say, don't worry about managing the amount of your estate taxes, let's just buy life insurance and we'll pay whatever it is. I will tell you that nothing will get you kicked off the planning team more quickly than that, right? Because everybody feels like the first thing you need to do is you need to reduce the estate tax that's payable, and then you talk about how to pay what's left. So let's talk about some ways that you can manage Jack and Diane's estate tax bill. Well, they could use discounting vehicles like family limited partnerships, grantor retained annuity trusts, things like that. And the reason you use things like that is that when you give away this property, the person who receives it, it is less valuable in their hands. So you have removed something from your estate, but you didn't use the full amount in equivalent gift tax exclusion, right? So with a family limited partnership, it's worth less to the recipient, perhaps because they can't control it or they can't sell it. A GRAT is less valuable in the hands of the trustee because the trustee has to pay a stream of income back to you for making that. So you, if you have someone with a really large estate, you want to think about making the value of the item less for gift tax purposes, okay? Now, for a lot of people though, especially with those crazy gift tax exemption and estate tax exemption amounts that we have, really should just be thinking about doing large gifting, because you can give away over $11.5 million this year and not have to pay a dime of gift tax. You can give away over $23 million this year if you have a spouse, and then you don't pay any estate taxes. Now, here's the tip that I want you to have, and that is if you're only going to give away a portion of that. So let's say Jack and Diane want to give away $10 million, but they want to keep $10 million for whatever reason. Either that's the amount that they feel like they need to have security, they want to give that away to charity, whatever. If they want to give the kids $10 million this year, the question is, should I give $5 million from Jack and $5 million from Diane? And the answer is no. You should give all $10 million from either Jack or Diane, because if you each give away $5 million and that exemption reverts back to $5 million in 2026, they have nothing left. But if you give away $10 million from Jack, for example, and Diane doesn't give away any, then after 2026, Jack has used up his exemption, and it's more than 10 million. I know it's 11, but he's used up almost all of his exemption, but Diane hasn't used any of it. So it is much, much better if you're going to use those large exemption amounts to make sure that you're using them in a way that is most efficient. And you don't have to worry about a thing that we call clawback. And what clawback says is, what if I give away $10 million and the exemption goes back to 5? Is the IRS going to come back and say, hey, you gave away $10 million during lifetime, but the exemption now is only 5? The answer is no. You don't have to worry about that. Treasury has already said that's not a problem. So you give it away. And if you don't give it away by 2026 or by the time they change the law, then you've lost an opportunity. Another way to reduce the estate is by utilizing charitable giving techniques. Now, there are a lot of techniques to give away property and money to charity, but the things to remember are really, if you want to reduce the size of your estate to 0, there are two things that you can give that property to. You can give everything to a spouse and not pay a dime of estate taxes. Now, that might be delaying it because eventually your spouse will die, and he or she will then have to pay the estate taxes. But the other way is to give property to a charity, either during life or at death. And that is a great way. So if you have Buffett or Gates or Bezos or any of those guys, they are under no more of an obligation to pay a dime of estate tax than I am, right? Because they could give it all away. And whether they do or not, that's up to them, but they could. So I encourage you now, if you talk to your clients about charitable giving and they do want to give away a substantial portion of their estate, talk to them about a wealth replacement policy. Because if they have a or if they give away $1 million, for example, that's $1 million that the kids aren't getting. And the kids aren't going to be happy about that. So why not just buy a life insurance policy, give that to the kids, and then give the other piece of property to the charity? I tend to think that it's a much better strategy to do a wealth replacement policy than it is to actually give the life insurance to the charity. But that there's some debate there. So I think that a wealth replacement policy is a great way of going. So I'm going to pause here and I'm going to do another polling question. My clients want me to bring up the topic of charitable giving. I either strongly disagree, I have no opinion, I agree, or I strongly agree. Okay, Andy, I think we're ready. Any more coming in? Okay, so the clients want me to bring it up. I am really glad that 67% of you agree. I sat in last year on a study group, the Chartered Advisor in Philanthropy. And I was fortunate enough to be a member of this group where there were other financial advisors, attorneys, CPAs, and some charitable folks. And people, after a while, you got the impression that they didn't think their clients wanted them to bring it up. And it's because they would, at one point, they would ask them and they would say, oh, well, do you want to do anything for a charity? And the client would be surprised by it. And chances are they would say, no, I don't think so, or I'll think about it. And the topic never came up again, right? So I think it's important that you understand that your clients do. So I am really happy to see that 67% of you do feel that, because that is borne out by some of the surveys conducted of high net worth people. So please continue to do that. If you're not doing it now, you need to. So here's the pro tip. If you do want to talk about charitable giving, number one, don't assume that the charitable giving conversation is about taxes. It is not, right? People have a lot of reasons for giving to charity. Either they're grateful for something, they're guilty about something, they just are happy, whatever the case may be. People have many, many different reasons. And nobody, almost nobody, wants to do it just because there's a tax benefit to it. Okay. And I will tell you that that's the question I get asked. People call me and say, well, how much could people save if they did a charitable remainder trust in this particular situation? And you maybe run the numbers and we talk about it. And then you find out the client wasn't charitable. Well, how did we get there? How did we get there? We got there because we thought that, or the person thought that a person would be more concerned about what the tax consequences of charitable giving are rather than what the real world consequences are of making that contribution. So instead of talking about what they can save in taxes, why don't you say, what do you most want to change or preserve in the world? You know, do you want to stop hunger? Do you want to stop homelessness? Is there a certain school that you want to make sure goes on into the future because it was great for you and your family? Whatever the case may be, what do you want to change or preserve in the world? Okay, so the next thing I would have you consider is generation skipping gifts, because a lot of times people will say, you know what if instead of me paying estate taxes, giving it to my kids, who then pay estate taxes again when they give it to their kids, why not just give it straight to the grandkids? And I will tell you that that's a great idea in many cases. But what I want you to be aware of is there is a thing called a generation skipping transfer tax. And what that means is that if you skip a generation with your giving, you may have to pay a tax equal to the estate tax rate. Now, I will tell you that there is an exemption which is equal to the estate tax exemption, but it is not portable between spouses. So if we look back and we talk about Jack and Diane again, if Jack died and left everything to Diane, Diane now has about $23 million of exemption that she could use, right? But for the estate tax, but she does not have $23 million of generation skipping transfer tax exemption to use. So that's going to be important. If people tell you that they want to do a lot of intergenerational planning, then you make sure that you're having a good conversation with their CPA and their attorney. So don't make this all about the taxes though. What do you want to pass on to future generations? Because it's more than passing wealth. It's about passing values, right? We want to talk to people about what's important. And granted, sometimes when we work with people who don't have a tremendous amount of money, then a lot of the planning is, let's just make sure there's enough money to stay in the house. Let's make sure that they can go to school and things like that. But as you get higher up in the wealth categories, you will see that people start thinking about, hey, what's my mark in the world? How is this family going to survive 2-3 generations down the line? So if we have that conversation, then we can really do some great planning for those folks with just a little bit of time and some good fact finding. So I encourage you to talk about those things in addition to just talking about taxes. So another quick polling question: how often do you talk with clients about passing on values? Never, not very often, sometimes, fairly often, or always? And we'll give this just a minute. All right, let's see some results here. Fairly often, that's great. And I'm glad that some people say that no one said never, right? Because that is important. But you can see that it's all over the board. And that is such an important part of estate planning. Don't get trapped into only talking about taxes. One, it's boring, and two, it's just not motivational. So talk to them about things that matter to them, and usually that's not taxes. Okay, so now we've talked about how to manage the taxes. Let's talk about how to pay for it. And like I said, we know that life insurance is great. It's a slam dunk, right? Life insurance, you're paying pennies on the dollar. So you give us a few cents every year, we'll give you $1 if you die while that policy is in force. We know that it's a self-completing plan. And we know that you can own it outside of your estate. So if you buy a $5 million, a $10 million policy to pay for your estate taxes, you can own it outside of the estate, or it can be owned outside of the estate in a way that doesn't make that $5 or $10 million itself make that tax problem worse. So we should look at that. And now we know that they've already done that once. We know they have a second to die policy. Do we know if it's sufficient? Is it a high enough face? Do we know if it's performed well? I mean, it's 1995. And if it was 1995, there's a decent chance they thought the interest rates were going to be higher for the rest of their lives than they turned out to be for the last 25, right? So maybe the policy hasn't performed well, and gasp, I know this has never happened to you, but maybe the client didn't fund it appropriately either. Maybe they got a few years in, had a rough year, didn't pay a premium, had a couple more years go by, didn't pay another premium at that point, and the policy hasn't lapsed yet, but it's not doing great. It's on life support. So in those cases, you really should consider a 1035 exchange. But if you are going to consider a 1035 exchange, watch out for loans on the policy. Because if a loan is paid off as part of a 1035 exchange and there was gain in the policy, then that is a taxable event. The client is going to get a 1099 in the mail next January, and the client is not going to be happy, right? They're going to call you, you're going to call me. Nobody's happy with that. So be aware that if there is a loan on the policy that gets paid off as a result of the 1035 exchange, there may be a taxable event. Now, there's ways to manage that. You might pay for that policy, or you might pay off the loan, I should say. You may try and find a carrier that will carry over the loan to the new policy. I don't know who does that anymore. Or the client may just be willing to say, no, go ahead and pay it off. I'll take the tax consequence because it's still not as much as paying off the loan. And that's fine. That's fine. Go ahead and do that as long as the client understands. But a lot of times people they don't even realize they had a loan on the policy. And here's how that happens. Some people will affirmatively go out and take out a loan off their policy. But other times you'll have someone who bought a participating whole life policy and they didn't pay a premium. And that policy happened to have an automatic premium loan provision. And so they took a loan from the policy, paid that year's premium. Maybe it happened again a couple years later. Then several years later, the interest has accumulated to such an extent that it is really a sizable loan. And those are the ones that are sneaky. So be very, very careful that you know if there's a loan on that policy. So ask for an in-force illustration. And also consider if it's a good idea to replace a 25-year-old policy. In a lot of cases, that thing, maybe it's not performing well, but maybe it is. It could really be rolling by now. So get that in force, take a look. And if the policy is doing well, don't replace it, just supplement it, right? So just keep it. But what if it's not the life insurance itself that they have a problem with? Maybe it is the fact that they have an irrevocable trust that they don't like anymore. And people don't like trusts for a lot of different reasons. But in this particular case, Jack and Diane have now had 25 years to think about what they bought when they paid for that irrevocable trust. And they may not like it anymore. They may have somebody that they don't want to distribute things to. They may wish that it was in a different state. They might wish it was a dynasty trust or had provisions for a special needs child. In all of those cases, they might say, you know what, I wish that I could get out of this irrevocable trust, even though irrevocable is in the name. And I will tell you that in 1995, people were not drafting much flexibility into these documents. So they are coming to you and asking, and you're probably coming to us originally. So here is the process that you go through. Number one, partner with the attorney. This 100% you cannot do without the attorney on board. There's just no way, you just can't. So some people don't like partnering in those cases, and they feel like maybe somebody, that people don't play their roles appropriately, but they have to have somebody, okay? Then what you're gonna do is you're gonna look to the trust document and see if there's any flexibility in it. Like I said, in 1995, there probably wasn't. And then next you're gonna look to state law and see if state law has anything. And if you do have to go to state law, there may be some provisions, perhaps you can modify it either judicially or non-judicially, which basically just means either you go to court or you don't go to court, depending on what the state says. There's a number of states now that allow for decanting a trust. And what does that mean? Well, for those of you who are wine drinkers, decanting just means you're pouring the contents of one bottle into another container. And the idea is the new container will have all of the wine and the old bottle will just have the sediment that you didn't want to drink, right? So picture that when you're talking about decanting a trust. You are pouring the assets out of the old trust where you don't like those provisions into a new trust where you do. So that decanting a trust is all over the literature now. I'm sure you've heard of it, but if it is available in your state, then it's the way that most people will go. Occasionally, you might want to sell the assets to a new trust because you would rather a particular asset be distributed differently somehow. That can happen. And so, but what I would say is be careful. If you're selling life insurance to a new trust, you might have a transfer for value problem. So here's the cure. If the new trust is a grantor trust and the grantor of that trust is also the insured, you have an exception. So that is how you get out of that. You can sell that life insurance policy from one trust to another, and you can get out of that transfer for value problem because you have an exception. So then you just have other concerns. Like you want to make sure that the trustee of the first trust is selling it for full value, because certainly the beneficiaries at first trust are going to come back and complain to that trustee if they didn't get value. And then finally, you may terminate the trust and just distribute those assets. But don't forget, as you're doing the estate planning too, to protect the family wealth. Perhaps there's creditors of Jack and Diane, excuse me. There might be creditors of subsequent generations that we're worried about. Every family could and should be worried about future ex-spouses, right? And we already know that Keegan in our family is a spendthrift. So he is the kind of person who should not be handling his own money. And we can protect him against himself with spendthrift provisions in a trust. So how are we going to accomplish that? We might with a domestic asset protection trust. I believe there's about 20 states now that have those statutes. And it might be another irrevocable trust, or you might use a business entity. A lot of people will use LLCs, for example, because of what we call charging order protection. And what that means is that we all know that if you form an LLC, you're protecting your personal assets from the business's creditors. But if you have good charging order protection, there is also protection for the business assets from your personal creditors. So that's a great way to protect assets as well for folks. And then finally, don't forget that you're trying to pass on both a business and you're trying to preserve the family, right? This business that they are in is more than just a source of income. It's kind of part of the family. And so you don't want that part of the family to ruin the rest of the family after Jack and Diane are dead. So let's have some conversations with them in advance about transitioning the business. Who should get it? When should they get it? How should they get it? Are we going to get it through will? Are they going to gift it to me? Are they going to sell it to me? Then you can move on to some more significant questions, like if we're going to sell to the children, where are they going to get the money? And if you think that kids are going to save up to buy your business from you, you're wrong, right? Kids don't save up to buy their businesses or buy businesses from their parents. The parents will always finance the sale on that. Not always, almost always, okay? Now, how are the family's members going to work together, and should they work together at all, right? We know that forcing kids to work together in a business might be hard on the business, but it might also be hard at the Thanksgiving table next year. So we have to make sure that we are talking about this during life. Who's going to be in charge? And what did we do? Why did they give 5% ownership stakes to these kids as college graduation presents? That's crazy. Don't do that as a rule, because when you give someone a 5% ownership stake in your business, you are making them an owner, and owners have rights. And you may not like that they assert their rights later on when you least want them to. So I think Kathleen might even be talking about some synthetic equity in her portion, which I think is a much, much better way of handling this. But in the meantime, we're going to have to think about whether they should buy those back or not. And then most importantly, figure out what to do with Keegan. We've got to get him out of the business. And what a better way than just buying life insurance, equalizing the estate for Keegan, and get him out. If it's $1 million, great. Whatever that number is, buy the life insurance, give the business to the responsible kids. All right, last polling question that I have, and that is, I am comfortable asking the soft questions to unearth family dynamics. Either not at all comfortable, somewhat comfortable, or very comfortable. And we'll just take a few seconds on that. Okay, let's see some results there. Very comfortable, outstanding, outstanding. Because if you want to work with wealthier people, if you want to work in family businesses, if you think that you can just ask questions straight off the fact finder, you're nuts. because what you will end up with is a fantastic plan that means absolutely nothing to the people, right? If you sat down with Jack and Diane and Keegan's name never came up, but you had a great idea of the financial situation of the business, and you talked about the best way to protect assets, but it didn't take into account that Keegan's going to ruin this family if he gets in the business, your plan is not going to be adopted. So I think that's just fantastic if you are asking those soft questions, okay? So where do we start? Well, a lot of times we want to sit down with these business owners, but they don't want to take the time, right? Because they're busy. If they weren't busy, we wouldn't want to talk to them because they wouldn't have any money or need any planning. But it makes it a challenge. So a lot of times we'll say, what if we just did a business valuation? Let's just get this thing started. And that way you can get people to take a step towards a plan. So you have to ask yourself then, should it be a formal or informal valuation? And I will say it has to be a formal valuation if you're looking to sell to a third party. You're crazy if you sell your business not having a very good idea of what that value is, right? If you want to use it with the IRS, then you have to have a formal valuation. Or if you really just want a definitive value, get a formal. But when might you use an informal valuation? We do informal valuations, for example. Maybe you just want to start an informal number just to get things going. A lot of times we find that business owners don't have any idea what their business is worth. Granted, a lot of them think their business is worth a lot more than it is, but there's a certain number of people that are really surprised to find that their business is as valuable as it is. So that'll help get it started. And that'll help you have a conversation that, hey, you have a thing here. You have an entity that needs to be protected. So we need to talk about key employee. We need to talk about whether you have appropriate coverages in the P&C area. We need to talk about whether you're maintaining your goodwill, whether you're using reliable financial reporting techniques, and that you don't do anything crazy on your way out the door and ruin the business right before you want to exit, okay? So think about those things and talk to them about diversifying clients, right? Having one great client sometimes feels great until you have zero great clients because they left. So that is a great tip for small business owners to increase the value of their business, and that is to diversify their services and diversify their client base. So what I really want you to take from this, as I said, it's 2 steps. Disturb them into action and then fund whatever plan that they come up with. Because owners of family-owned businesses have a lot of issues. That's why we covered so much ground today. But most of them are not even tax related. So you can help them, not just with the products you sell, but you can help them with the way you do planning. So I encourage you to go out there and do that. And to learn more next week, I would ask you to tune in and see Kathleen of Affinity Law Group, because she's going to talk about succession planning for Generation 2, retaining Maya, using executive benefits to tie key employees, and using life insurance to informally finance executive benefits. It's going to be a fantastic session, and you're going to learn a ton. So I hope that you come back next Wednesday. And with that, what I'd like to do, we have about 5 minutes left for questions, see if we have any out there.
Yeah, Ron, can you hear me? This is Rob.
I can.
Yeah, I do have a couple questions. We'll see what we can get to. You
Great.
mentioned or talked about, disturbing them, and the fact pattern references mom and dad have been delayed and confused. Could you say more about how you might suggest that disturbing, motivating, guiding, how you could help them move forward with some of the planning that you've expressed?
Absolutely. And I think that this is true in any type of advanced planning. And we see it. And Rob, I know you do a lot of business succession planning. So I think the issue is you have to find the bruise, right? You have to figure out what people care about, because if you talk about an issue, no matter how important you think it is, if they don't care about it, they don't care about it. and you need to move on. So if they don't think that they're going to die soon, then don't talk about that. Talk about incapacity during life. If they don't think that they're going to die and leave the business, talk about if a partner might die or a child might die. All we want to do is we want to get them started, right? And so you also have to understand it, and I know you guys face this because I work with a lot of you. Sometimes it doesn't matter how hard you try, people will put you off. And so what I would say is talk about what they want to talk about, handle that particular issue, and then next year come back and say, hey, I really think it's important. Last year we didn't talk about the succession planning for the business, or last year we didn't talk about the estate tax issues. Let's talk about it this year. And if they still say no, bring it up next year. I don't know if you have anything to add to that in your experience, Rob.
Oh, thank you. No, that's very helpful. Why don't I, Ron, go ahead and pick up this next question, and I'm trying to paraphrase. It's a little lengthy, but
Okay.
Essentially when you referenced the getting the attorney involved, if you could speak more to collaboration, whether it is in the example you had in your presentation with the attorney and or when the CPA might be involved. I know you referenced valuations, both formal, informal. So generally speak more to the collaboration and the importance of that.
Okay, great. I think one thing to really understand when you are working, especially with CPAs and attorneys, is that if you are working on commission and they are working on an hourly basis, every minute that you're talking to them is a minute that they are not making money, right? And so respect how people make money. Go for coffee, do something like that, or call them specifically to talk about a case. Now, I do think that that's a great way to work with those folks, but I think you should work with some local counsel as well. Get involved in your local estate planning council. Get involved in your local organizations to meet some people and to talk with them. And you don't necessarily want the general partner of the firm, because the general partner of the firm is already working with a lot of other financial advisors, right? Build relationships. And then once you actually get into a case, I can't encourage you enough, have everybody respect their role. And by that, if the attorney says, you know what, we have an irrevocable life insurance trust and I don't think we should send out crummy notices, you don't have to throw your hands up and say, well, that's crazy. You have to send out crummy notices in an irrevocable life insurance trust. Respect your role. And then if they come in and they say, I don't think that's the right kind of life insurance, then I think you can demand that they then would also respect your role. So respect time, respect role, and build relationships. And I think that's your best route.
Excellent. Thank you. And I hear those two words that you've shared before about cooperation versus collaboration. And what I'm hearing is indeed that collaboration. So I appreciate it. That was fantastic. Gosh, really a sincere thank you on behalf of the Society and NAIFA both. We were off to a wonderful start. And as you indicated, we will have session 2 or part 2 next week. I should mention that the slides and the recording of the video will be posted on the site. That question did come in. And then as we conclude, I do want to hand it over to Keith Gillis, please. Keith?
Thank you. Thank you both, Rob and Ron. Ron, what a great job today that you've done. I want to thank the Society and also NAIFA for helping us put this on. And we look forward to seeing everyone just 1 week from today, same time, with part 2 of the Feldmans. Thanks, everyone, and have a great rest of your week.